The complex process of upgrading Europe's data laws for the digital age is a process that many of us have followed for many years. And this panel, which is a hallmark of CPDP, is an opportunity to hear from many who have been at the coalface of these negotiations. They come to us with some triumph and some battle wounds, and I hope we'll be able to hear about both of them today. To kick us off, we have Brung Gencarelli from the European Commission. He has been leading the Commission on data protection on both the directive and the regulation, and he's had some late nights and early starts recently in the process of trying to negotiate a new safe harbour. So, Bruno.
Good morning, everybody. Okay. So I'm, first of all, very pleased to be here also this year, and I'm very pleased to be on this panel. I feel extremely honored and privileged to sit in a panel together with members of parliament, including the two rapporteurs. One of the rapporteurs will join us. Throughout the legislative process that eventually led to the political agreement we reached in December, the European Parliament played an absolutely key, essential role, pushing for the reform when the other co-legislator was, let's say, moving at a much slower pace, insisting on the package approach, meaning the adoption of the regulation under the directive when few believed in it, emphasizing the need to guarantee a high level of protection. Those were messages that came very clearly from the European Parliament throughout throughout the process we went through. So I'm really pleased to be here. So we are now a bit more than 1 month from the political agreement that was reached in the context of the trilogue. The formalization of this agreement will take some months, but the substance has been agreed in December. And at 1 month of that famous evening of the 15th of December, I guess it's time to ask ourselves a number of questions, which I think are some of the questions this panel seeks to address. I will just briefly mention them. First, a very simple but basic question: is the outcome of the process a good one? Second, what were the conditions, the ingredient of a process that we at the Commission consider a very successful process? And third, what's the way forward? What are the prospects for data protection in the EU? So first, I'm sure it won't surprise you if I'm telling you that we at the Commission are extremely pleased with the outcome of the trilogue. First of all, because the two instruments, as I already said, were agreed in December. In other words, the package approach was kept, which is itself a success if you consider where we were only 6 months ago. And it's a package with actually a great deal of coherence between the two instruments, which is also an important element. Then, I guess we are going to come back on all these issues during the debate in answering to the question, but when looking at the substance of what we have agreed, we believe that this is a good reform which will deliver more harmonization, and not only in the books, not only on the paper, but also in practice, simplification of the regulatory environment, an updated mix of rights and obligations, including through the introduction of new tools, new rules, such as data portability, such as data breach notification, to give two examples, and also needed shift of paradigm of approach, moving from an ex-ante approach to an ex-post one, relying to a larger extent on accountability and credible enforcement. Then the second point I wanted to briefly mention is the process itself. And why this process, which was clearly, because also of what was at stake, a long and complex process, ended up as with a successful outcome. And I just want to mention issues that are relating more to the methods we have followed, especially in the trilogues. There was, from the start of the trilogue, I think, a clear method, a clear roadmap with few parameters, which were, I think, respected and which helped the process. And there were essentially two parameters that we should respect and not fall below the level of protection of Directive 95, which was, I think, something, not I think, but which was something shared by the three actors and institutions around the table. And also, after such a long process, a long reflection by the three institutional actors, an agreement that the compromises that needed to be found would be found within the parameters of the three texts that were on the table, the proposal of the Commission, the general approach of the Council, and the position of the Parliament. And of course, it was not always easy, and of course, it was not always a walk in the park. But I think that what is remarkable with such a complex text, with so many issues, is that the compromise that were reached on many issues were not only about seeking the minimum common denominator. Actually, throughout, and also compared to what we had proposed as the Commission, you can see that innovative solutions have been found, new tools have been introduced. I would just mention some of them. From the governance side, the one-stop shop mechanism that you see today, the consistency mechanism today, strikes a very interesting balance between, yes, an injection of more proximity to the data subject, but on why I'm talking about the balance, this is balanced by much more important role for the European data protection, the future European Data Protection Board as a real dispute settlement resolution body. New tools, for instance, the introduction of icons to ensure meaningful and user-friendly information for data subject. An interesting the clarification of the concept and the contour of the concept of consent, relying on the notion of affirmative action. There are many examples, but those are some examples of, I would say, the positive compromise that came out of the trilogue. The result we have, I think, on the table is also on the top, and in addition to the method that was followed, is also, I think, the result of a healthy sense, I would say, of urgency. Europe had waited already too long for a modernization of its data protection rules, and there was a realization that the data protection reform was needed, is needed even more today than it was 3 or 4 years ago, as an essential element of the digital economy and single market strategy. Data protection is an essential element of trust, of confidence. I mean, I don't need to expand on that, or we will expand on this certainly. But data protection, common rules of the game in the area of data protection are also needed in the area of security, of law enforcement, to ensure a more efficient, a quicker, and more legal certain exchange of information between law enforcement authorities, and that's of course needed for obvious reasons. So very quickly, what are the prospects for the future? So we will have to do in the 2 years transition period a number of things. Us as the Commission, we will have to propose the alignment of certain instruments, such as the Regulation 45/2001 on the rules applicable to our institutional bodies, the alignment of the e-privacy directive with the new rules. And, but we will have also, and this is a different role for the Commission and institution, make the best use of the 2 years transition period to contribute to build an environment that would favor the application of and the compliance with the new rules. and that, I would say, concerns a number of aspects. It concerns contributing to the establishment of an effective and sound governance system. We are clearly changing, there's a clear change of, and radical, I would say, quite radical change of governance system in the data protection world. So a well-functioning one-stop shop, a well-functioning board, that would be real test for the efficiency and effectiveness of the rules we have agreed. And we will also have to promote, support, facilitate the development of a number of tools of compliance. As you know, the process has substantially reduced to use an understatement, the classical tools of delegated and implemented acts, but has certainly introduced more references to codes of conduct, guidance, certification mechanisms, and those are very important tools for compliance. And last but not the least, now that the House is in order in a certain sense, that we have our rules in place, our international role will most probably be even more relevant. A number of countries around the world are equipping themselves for the same reasons as we did, with modern data protection rules, and they are looking at the EU as a source, as a clear source of inspiration. Actually, we focus a lot on the very important transatlantic relationship, but around the world there's maybe more convergence than divergence, or there's an increase of convergence on these issues, and we probably have an important role to play. And we will also have to contribute to the establishment or to the conclusion of other important instruments. I'm thinking, for instance, of the modernization of the Convention of the Council of Europe, which is a very important reference point and compass in the data protection privacy world. And there, now that we have adopted our rules, I think we can give a very important contribution. So I've already spoken too much, and now I leave the floor to the real protagonist of this panel and of the reform, more generally speaking.
Thank you, and thanks for the work of the Data Protection Unit and its cooperation in this. So our next speaker is Jan Philipp Albrecht. He's a film star. If you haven't seen it, I highly commend David Burnett's sublime documentary, Democracy, screening tonight and at good art house cinemas near you. And in it, Jan and his colleagues here feature in a really different take on the process and machinations of Brussels. It's a really good film. But in his spare time, Jan works on data protection as Vice Chair of the LIBE Committee. He's also the rapporteur for the Parliament on numerous processes, not least the Data Protection Regulation, the Umbrella Agreement, and TTIP. So thank you.
Thank you very much, and thanks for the invitation to this important panel, because it's the first panel after years of many panels where we always talked about how this law should look like, where we now know how this law will look like, because the institutions, as Bruno Gencarelli lined out, have found an agreement, especially negotiations between the two texts adopted by Parliament and Council have led to now one single text, and a consensus is reached. And I think that's a very important signal after 4 years. I think it has been 4 years and 2 days that the Commission has proposed its proposal on the data protection regulation and on the data protection directive, where Marju Lauristin managed to also find an agreement on the directive, and will most likely also touch on the substance of that. I will concentrate on the huge achievement which we got in December on finalizing the regulation. I think that we can't overestimate the impact this will have, not only on the question of the future development of data protection and privacy laws in the European Union, not only even on a global level, but also on the development and integration of the European Union and of the global community when it comes to legal principles, fundamental rights, constitutional principles in general. I think that this is a very important step also for the European Union as a whole. It's the first time that we regulate by a regulation which is directly applied, directly applicable, an area of a fundamental right, which leads also to a further development in how we decide together on important decisions in the European Union. But I think the most important in times of these is to say that it is an important symbol and signal to show that Europe still can deliver on very complex questions in a globalized economy, in a globalized environment, and in a digitalized environment and life. And this is not only important for those who are here dealing with the issue of privacy and data protection, but I think this is important for everyone, as it is a signal for each and every area of our lives, and the possibility to answer questions, complex questions, by political leadership in a democracy, in rule of law based states like we are living in. And I think that's an important issue to be mentioned at the beginning. So I would also at the beginning like to therefore thank all those who have worked consistently and persistently to get this law done, struggling to always find a compromise in an environment, of course, of so many different ideas, so many different interests. I mean, we have to think about that. Each and every of us, and also of every company, of every authority, is affected by these legal rules, which we now lay down, will be affected in the future even more and more. This is touching on all our lives, and therefore, of course, it was a long struggle. And it is good that it has been concluded successfully. So thanks for everyone who has worked towards this. In particular, thanks also to those who are not represented today here on this panel, which are those sitting in the council, in the member states, representatives, especially those who did the council presidencies throughout the last 4 years. In particular, I would like to thank the Irish and the Luxembourg presidency, who did great jobs in concluding a compromise in the council also between the member states, which is a huge task due to the 28 very different laws which we had in place, and different legal cultures, and also, of course, different interests. And I think it's remarkable that it's those two countries which I mentioned which are struggling with the fact that they are hosting big international players being touched on quite directly by this regulation, while my own home country, which calls itself the origin of data protection, sometimes has been a bit more complicated in these negotiations, and sometimes it's therefore important on European procedures, European Union's procedures, that we look very carefully what we are talking about and not try to simplify completely the debates. I really think that there has been many people involved who try to achieve something remarkable, which is important. Why is it important? We all know it's creating a single level playing field for data protection on the European market. We all know it's creating for the first time a real binding consistency mechanism so that we can have consistent interpretation of enforcement of these laws, because it doesn't make sense to have just one law if afterwards everybody is reading it differently and enforcing it differently. It makes a difference because we have a sanction regime which allows us to enforce our laws in the European Union, in the market of the European Union, based on the market location principle, so that everybody has to adhere to the same rules here. And it makes a difference because we have modernized this data protection rules. And Bruno already touched on that issue, but I would like to, also coming to an end at a certain moment, but I would like to certainly also touch on the issues of what have we done substantially, not only in the way to harmonize, to better enforce, to better consistently apply the rules, but also to substantially improve data protection rules. And I just would like to line out that I think there are very important new steps, starting, for example, with technical standards, which we introduced now for the first time in the legal environment of data protection laws on the question of standardized icons, already mentioned. By the way, here also another thank you to my former colleague Alex Alvaro, who was originating this idea in the parliament, which is also the technical standards on the opt-out opportunity by browser settings, the do not track signals, for example, which was deriving from my draft report in the parliament and stayed until the end. The concept of pseudonymization, which I introduced in this legislative procedure, because I think, and I thought at that time already, that this is an important clarification, because we need a concept of pseudonymization in the area of data protection laws, a concept which builds on the fact that this is still personal data, and this needs to be protected therefore, but that we need technical means to allow for easy and reliable pseudonymization, in particular to also allow for better communication between data subjects and controllers, and for further security in the light of the amount of personal data which we are processing today. Then we have a huge catalog on data security measures, for the first time enshrined also in this law. I think it's important to look at those things. This is further developing dramatically the data protection and privacy legal environment into a minimum standard, at least also in the area of data security. We need to further work on that, that's completely sure, not only for personal data, but for every information and telecommunications technology. That's still not done, and I think the Commission would be rightfully placed to allow for new legislation on the area of data security and of IT security. And we have new concepts like the right to data portability, the right to be forgotten, originating not only from the Commission's proposal, not only from the court on the right to be forgotten, but also from a resolution already adopted in the European Parliament 2011, where we called on it, where Axel Voss was the rapporteur for. And so I think that we did consistently a very good work on achieving a modernized data protection law, which now hopefully will be applied latest in June 2018. We still need some time for translations to be done so that it can be formally adopted and put into force, but I think that this is a good timing. Maybe we are late. I already thought that at the beginning of my rapporteurship, but better late than never. Thank you very much.
Thank you. I think some of those points about pseudonymization and portability will be picked up by other panellists. Our next speaker is Michał Boni, who joins Jan on the LIBE committee and has been a long time, as a minister in the Polish government, been a long time advocate of privacy, internet freedom and other mechanisms for making a more digital economy. So thank you.
Thank you very much for invitation to this panel, as I believe this is a very important moment for us. The trilogue negotiations are over, and colleagues attending this panel have worked very hard to achieve the good and workable solution. I would like to thank them for the work done. The adopted GDPR is not the perfect document, but it is one that provides harmonization and creates new data protection framework building on the trust of all involved parties. It is in this respect a very important instrument and a basis for further development of digital single market. It is also an important instrument for the transatlantic relations. It is necessary to have one harmonized approach and framework on the European side to be able to set the rules with the United States, especially now when we are trying nervously to find the solution related to the safe harbor. I hope that in the light of the GDPR, we have for the future some additional tools for finding the solution for so-called safe harbor with mutual advantages as for Europe as for United States. The directive is also very important, as in many member states This is the first comprehensive instrument to regulate data protection for law enforcement. This instrument sets rules but allows law enforcement to carry its duties. Unfortunately, now in Poland, I'm from Poland, as it was mentioned, there is a new law, so-called invigilation law, with any respect to the rules approved in this directive. It will give the right to police and all secret services during their operational activities to have access to the data and to the content made and used by people, but without earlier court's decision and without the list of serious crimes. I hope that implementation of the directive will give us some new tools for changing this anti-citizens, intrusive into privacy solution. But let me get back to the GDPR. After final adoption of the package, we will enter 2 years of implementation or adjustment period. I believe this time ahead of us is very important, is crucial. It will influence on real positive impact of the implementation of this regulation. We have to make sure it is used wisely. This is a very complex regulation, and we have to make sure that everyone knows how to apply adopted provisions. This is important as I believe there are still few issues that need to be looked at, possibly during the implementation period. So now I will present some recommendations related to the implementation plan. First of all, this is the issue of adjustment of the e-privacy directive. We should aim to have harmonized set of rules and to this end look for timely adjustment of e-privacy directive while ensure further development of the digital sectors. There are different scenarios what to do with e-privacy directive. Some could argue that we don't need e-privacy directive at all, that we should rely on GDPR for data protection issues and make sure during the implementation process of GDPR that the issues within e-privacy directive are addressed, and the rest is addressed in the telecommunication legislation. Some will argue that since we did not make sure that all necessary elements are in place in the GDPR, we need a revision process of e-privacy directive. What we know now is that the Commission will start the review of this instrument with a public consultation, most probably announced in March this year, and as an effect will present some proposed solution early 2017. And of course, there are some additional points that have to be still addressed to the implementation process. 1. GDPR either leaves certain technical issues for implementing and delegated acts or leaves flexibility for the national solutions. There are 54 options for national implementation. While it seems to be a good idea to have this flexibility, we should make sure that we will not lose the harmonization and we will not end up with, again, 28 different frameworks. So I believe that we need guidance from the European Data Protection Board in how to interpret certain provisions of the GDPR, but also what would be the best way to, while ensuring flexibility, don't lose track of harmonization. 2, I believe that when GDPR will be applied, the European Data Protection Board should also keep track of the innovation and make sure to give guidance to ensure high level of data protection while not impede innovation. 3, there are also some issues still raised by some stakeholders, like for example controller and processors liability. We might need clarification as it comes to the share of liability. Many argue that we should rather move away from a joint several liability to subsidiary liability system. This is something that we should definitely clarify so everyone knows how this provision should be applied. Another point is the issue of data portability. I believe that the feasibility of portability of data directly to another controller should be analyzed, and we should know exactly what does it mean. The notion of where technically feasible introduced in the text. This is also needs some guidance from European data authorities. We have also the provision of an age of children in relation with consent for information society services. The regulation says 16 years, but allows that if in the member states law lower age exists, this can remain unchanged. But it has to be not lower than 13 years. There is a certain risk that will lead to a sort of geo-blocking. I do understand that there are differences in the member states' law in this respect, but we should make sure that repercussion of this provision is minimal for harmonization. Two issues that I believe are very important in the implementation phase. Within 2 years, we need to be especially careful about SMEs. The GDPR has introduced risk-based approach to several provisions. Some refer directly to SMEs and others differentiate obligations for low and high risk. It is necessary to make sure that the obligations are not excessive, especially for SMEs. The least we can do is to make sure that appropriate guidance is prepared regarding obligations for SMEs. And last but not least, big data. I think that Axel will express this problem. We have made sure in the GDPR that data can be used for scientific research purposes, as stated in Article 83. We have also made sure that the medical research is possible. By introducing the concept of pseudonymization, we try to allow big data development at the same time protection of this data. But we need to develop this understanding, as Jan said, because the digital world, the digital economy is going forward. The General Data Protection Regulation is not the burden. It is the opportunity for trust among all sides, all partners, and this is the opportunity for real sustainable digital development. So we have to work commonly together on the best way of implementation. Thank you.
If you think you are steeped in the data protection brief, consider Marju Lauristin. She has done research on profiling data protection for a very long time as a university academic and as a distinguished parliamentarian in Estonia and Europe. And we look forward to your views. Thank you.
Thank you very much, and thank you for the invitation for this really very important and in this sense also very pleasant, very professional exchange of views. And yes, for me it was really a very big change of role when from the academic field where I was for whole my life dealing with data processing, including all kinds of statistics and profiling even before the digital age, I then came over to the data protection area. And I have to say that for me it was in this sense also very interesting that this is an area where we are in a bit different situation compared to the many other fields of legislation. Normally legislation is really relying on the existing culture. In order to be legitimate, the law should correspond to people understanding, normative understandings, what is good, what is bad, what is appropriate, what is not. But in this virtual world, there is so many novelties coming in every day that really this kind of the general culture is in the very, very first stage of development. And so setting rules by law, we are also really introducing the new cultures. And I think that in this implementation period, it will be even more obvious because in implementation period, we have these general rules to immerse in the everyday practices. And from that, the new culture have to develop. Now, why I'm speaking about that? Because in this text, if I look at this text, what we now adopted as a law, I'm as academic, I see a lot of things to develop, maybe to make more, say, exact and so on. But it is a matter of future when this culture and this practical test will be already with us. And my really best hope is that the text will remain in this sense open. It was reminded that the data protection supervisory agencies, the supervisor, the board, so on, they are one of the ways to bring in new experiences. But I hope that also we as members of parliament, our committee, will be open to all kind of emerging experiences and see how they will be compatible or how they are bringing in new, still untouched, unsolved problems. And I want to mention a couple of them. At first, when we speak now about digital single market, then our understanding what could be the reality of digital single market after, I don't know, 3-4 years, it's still something which belongs to the realm of the imagination, maybe even dreams. In the first steps already, we meet some problems which are not so easy to solve. I just mentioned copyright problem. But also when we concern now data protection, then the nature of data itself in this digital single market, in digital economy, what really is that? Because when we look at the everyday activities, we all are producing enormous amount of all kind of raw data. But in the economy, when they have their added value, they need some kind of application, some kind of say, processing in a way that they become the asset. Now, when we look at all experiences concerning data analytics, the big data and so on, it's still the first steps. And there is a very big gap between those who already have this kind of experiences and those who only can imagine what could it look like and what will happen. And for that, in our regulation, there are some very general rules, but there is no very exact rules, and they cannot be there. But what is important here is to make very clear difference, more and more clear, between the methodology itself and between the applications, between the usages. Here are the simple parallels. Gene technology, the same thing. All is possible, but not all is desirable. And even more, not all is really, say, allowable in the human environment. The same thing with other things like nanotechnology and so on. So big data, data digging, data analytics, it's something of the same line, really. It's all about information and how we use information. And here, I suppose, we will have a need in maybe 2-3 years to come back to watch usages, not just methodology. Because now we have understanding, and that's very simple. Try to protect from applying methodology, but it's not the final way. Final way is to have methodology to develop as far as possible, but then to look what kind of usages should be tackled as dangerous. And then the other thing, what is, I suppose, more and more important for all of us is cloud computing. Because cloud computing is really the new thing, and in practice it's connected with the problem that big amounts of data, they are really stored and processed in locations, physical locations, which could be far away from borders of European Union. They could be as in the other side of Atlantic, as the other side of the Pacific, and security of this data and the rules applied there, they are not quite understandable and transparent. In our data protection regulation, we have set, I suppose, very properly, that by my mind is one of important, very important parts of that, the relationship between controller and processor. And now it really gives us rules how to proceed, how to go further also with cloud computing, to make cloud computing safe and also have the responsibility shared and responsibilities defined. That means that really the world of the digital, it's in some sense, it's like the world behind the mirror. When in the normal life, we are used to reflect on some things which are complicated for us, for example, mathematics, and then not reflect on some things which are practical. We have done them thousands of years. Then in the digital world, it's opposite. We are not reflecting very much on mathematics if we are already there as professionals, but we have to reflect on the simple human things which are not automatic in this world. And I suppose that's the way how we have to proceed to understand that culture is everywhere, but it is a new kind of culture which have to develop. And now come to my own directive file. I have to say that that was in this sense very interesting, because if in the data protection regulation we were on the, in this sense, very common and human ground, because it concerns everybody in all of everyday small things, and we all have some practices there, better or less. But then when you come to the area of law enforcement, then for many of us, the area of law enforcement is maybe best known from the detective stories, not from the real life. But there, the peculiarities, the national rules, the traditions, they are also very long. The culture of the law enforcement in countries is very different. And I suppose that not all of us, not all of you, can really imagine the gap between the law enforcement culture, for example, take Romania, Bulgaria from one side of Europe, and UK or say Sweden from other side of Europe. Nordic, southern, east, west cultures in law enforcement are very different. Cultures of law enforcement in post-communist or post-totalitarian countries are very different from law enforcement cultures in the old democracies. And that meant that when we didn't have this kind of common rules, that each of those national law enforcement system had own understanding. What is a privacy? What is a right of person for own data? What is a right of person to be protected in court, and so on, so on. Now it is a first time when we bring in, for all those 28, for those who feel themselves far away in democratic tradition, and for those who are just beginning to build it up, the set of common, really minimal standards. How to deal with privacy, with dignity of person concerning data, where are the legitimate grounds to breach that, how the responsibility could be achieved through the oversight, and so on. And I hope that we will go further in that. We discussed in our committee just yesterday the issue that, for example, national security is just now given only to the member states to decide what is not, and how data are processed and used in this field, which is like the camera obscura. It occurs that there are also differences. There are a lot of countries where there are the public accountability, the democratic oversight, and then there are member states where there is nothing, where data protection system is not achieving anything, not reaching the system at all. It's all covered. So I hope that the directive and work with law enforcement will help also to go further, so that we will have the whole this area covered, and the people, citizens in all member states will feel that their rights are in the same way protected. And then we come to the problems with EU, US, and all other things I will not touch here. But I suppose that we are going in this sense to the right direction concerning the rights of citizens, concerning privacy as fundamental right. Thank you.
Thank you very much. And our final speaker is Axel Voss, a distinguished lawyer and parliamentarian who has a very essential brief of working on relations with Australia and New Zealand, and also does legal affairs. Thank you, Axel.
So I also would like to thank you for the invitation, and I'm pretty sure that my colleagues can't stand my moaning and groaning about the regulation. But so if we have had, and my assistant edit these or some these, 123 hours of trialogues and shadow meetings. And this was a very intensive time, a very painful time from my point of view. And but I would like to thank you, all of you, also the Commission and the colleagues in Parliament, and because the worst was avoided from my point of view in the GDPR, I would like also to thank you, the Council, with the chief negotiator Lore Wagener and her team, and I see in the back some of these representatives from the Council, so thank you very much for your work. So I'm relieved that we have finished the negotiations. Nevertheless, I'm not that happy of the outcome of the text. It's too complex, it's inscrutable, of numerous vague wording, and it creates a little bit of, or not a little bit, but it creates legal uncertainty, and you can interpret the wording of this GDPR in everything. It's possible, or it's possible although we have this regulation. And so it's from the two polars, you can interpret everything, but the implementation phase is now a very important one, and this is what Michał Boni already mentioned, and so this will be seen in the future. But so did we achieve what we have had in mind at the beginning? I'm a little bit doubting that if we are coming to full harmonization. So the text is a regulation, but it contains a high number of opening clauses which gives flexibility to member states, and so you have the feeling this is a kind of a thing between directive and regulation, and so the numbers of opening clauses are, from my point of view, too much. This was definitely neither in the Commission's intentions, nor in ours, but now we have these opening clauses installed. So is this boosting the European economy? I think this regulation is a kind of a missed opportunity in conquering the digital European business, because we haven't achieved an easy access to data in a way that we are not infringing the fundamental rights of the individuals, and having at the same time the possibility to take advantage of the data to create new business models, for instance. So have the consumers or individuals have better rights? Here I can say clearly yes. The rights of the individuals are clearly improved, and they have a lot of rights, and I hope they will keep the overview of their rights, and so I would say this is what is really has been improved. Is the regulation a better chance for European SMEs? So there's not really a kind of a concept of SMEs included in the text. It's the other way around. The big companies won't be challenged by the new data protection law. The data protection law, from my point of view, will hamper growth and the European economy. It will not boost the economy, nor will it create a kind of a level playing field with other regions in the world, like Asia or the US. And it will have, and Jan already mentioned this, have serious consequences for the European business and its enterprises, and in the long term. And I hope it won't be a reason, at least, for shipping your enterprises to other regions in the world. And So certain provisions tend to create additional burdens, requirements, or restrictions of business. Those aspects will deserve much consideration in the implementation phase of the regulation. So therefore, all the stakeholders should include including the European Commission, national data protection authorities, and the industries have to work closely in the upcoming 2 years to find concrete solutions and practical solutions that meet both the interests of our citizens and our industries. Is the regulation big data proofed? Big data is one of the utmost importance for our future economy. However, the GDPR, from my point of view, limits big data application, and it's very challenging for all big data services. The text includes a very weak and very low level of big data provisions, setting out the factors to be considered in determining whether the secondary purpose is compatible with the original purpose, and the possibility for processing for incompatible purposes in a certain limited circumstances. So, however, the GDPR is, from my point of view, very complex and very cumbersome here. The European Data Protection Board is established now as a kind of a significant decision-making body in the interpretation of the GDPR, and from my point of view, this is exactly the problem. The European Data Protection Body will have too many competences and will be too powerful at the end. And for me, I'm always saying this, it's for me like the Chinese Central Committee somehow. And so a further crucial point is the collective redress. So we have been always against the inclusion of collective redress in the text, but however, it's now the other parties have a different position on these and do not share our concerns, but at least the negotiations in the trilogue avoid also here the worst. So citizens can only mandate a non-profit organization to lodge a complaint and on his behalf, and if his rights have been infringed. So this might be okay. But as a conclusion, just to be short, the GDPR is better than the Directive 95, but in its structure, it's not adequate anymore for a data-based future. So we all have the feeling that our future is totally data-driven somehow, but what we are doing here is at first saying data processing is forbidden. So you can see this is probably not the right approach to our future. So the GDPR is good for the individuals. It's bad, from my point of view, for the European company. It's too much bureaucracy, and so pseudonymized data were already mentioned. So yes, thanks for introducing these to the text, but from my point of view, this is not a concept. If we would have a concept, then we would have used pseudonymized data as a new data category to give some more possibilities to everyone. But now we have this installed only as a kind of a technique and for protecting more the rights of the individuals. At the end, I would say this is a kind of a missed opportunity to meet the upcoming data-driven world in a more balanced way.
All right, well, we have some material for a knotty debate, I think. I want to allow some time for questions, but I'll just ask one question each. Both Jan and Bruno, you said that this is a real example internationally that will help guide and shape behaviours. What do you think in terms of tangible impacts this might immediately have on some of the major internet players? I'm thinking Google, Facebook, Uber. Are there immediate changes that you think might occur as a result of the new regulation?
Okay, I'm happy to start. First of all, immediate changes, there are none. Because if and when this regulation is then formally adopted, there's a 2-year period until it will be applied. This is with intention there to allow for everybody to get used to the new rules. And always, if you pass new rules, you need to get used to them and you need to adapt to new rules. And if somebody would have expected that if you do out of 28 different laws, one law, and it will exactly look like one of the 28, then you don't know how European legislation is done. That's completely impossible. It's a compromise, and that means everybody has to move together. Not only moving to find the middle ground, but moving to a good solution for everyone. And I think that's what we found. And of course, there will be therefore an impact, an adjustment necessary. But I think also that the regulation, and that was also our leading line, is following the basic principles and the outline of the rules of the 95 directive. That was, by the way, one of the most important sentences in the resolution of the European Parliament in 2011, July 2011, which Axel Voss was the rapporteur on, once again, where the Parliament said clearly to the Commission, when you're drafting your legislation now, start from the level of protection of the 95 directive, based on the principles and definitions and rules set out in this directive, because this is not wrong, but we need to improve it. We need to follow up to it. We need to better enforce it and to have a consistent application with more clear definitions, with new modernized standards involved, and that is what we lined out there. And that's, I think, also what we achieved now. For the major players, I think that the impact will be a very positive one. Because especially for those acting globally, this will mean you can rely on one legally certain standard applying for the European market, which is the biggest market in the world. I don't think, therefore, that there would be any global player who could just move out of this market. It's just like, if you do that, okay, you can, but it would be an economically very stupid decision. It's the opposite. Those companies are moving into the European market due to the fact that this legal standard will now also serve not only as a reliable gold standard for the global market, meaning also in the sense of the debates which we have on this conference on things like surveillance, that you can see there's a secure environment in the European Union, but also that you know that you will get trust of consumers, you will get better market opportunities if you will serve this standard, if you will implement this standard. And therefore, I think for those it will be the most positive, but I think also that especially for European SMEs, and most of them are in the IT environment, this is a very important move forward because it's creating this level playing field, which brings them on an eye-to-eye level at least with those global players. Not like now, where it is like a subsidy going to the bigger ones, that they can choose the jurisdiction in Europe, which is the most, the nicest for them, while the Baden-Württemberg-based company producing automated machines, which now has to go digital, can't just move its company because they also have reliable workers and their families living there, which they don't want to leave behind, and so on. They now can trust that they are on a legal standard eye level with those players, that they can compete, and if they are better, if they are selling better, if they are more trustful, then they can also win this competition. And I think that is the best thing what we can do as European legislators, strengthening the strengths of European IT companies in the way of making them compatible also vis-a-vis to these global players. But we're doing it on favor of all the sides. It's a win-win situation for the global players, for the SMEs, for the consumers, and I think also for the authorities at the end, because they can work with this better than now.
there's very little to add. I share everything that I said, and indeed those rules will bring to the small and the big players more legal certainty in terms of which rules apply, which authority is competent, cutting compliance costs. But also, as Jan has said, those rules don't fall from the sky. The regulation is, I would say, a mix of continuity and innovation in terms of data protection. The basic the core of data protection rules are already they are already applicable. But what is certainly true is that data protection with this regulation becomes even more relevant. Not only because there will be a higher cost for non-compliance, but there will be also a higher value for compliance. And the players and the big players know that already, because they have also consumers and users that are increasingly sensitive to data protection and security. Therefore, meaning that brings me exactly to the type of remarks Jan has elaborated.
A very quick question for Axel. I share your some sympathy with the points you made about the lack of harmonisation on certain areas. On the data-driven potential, what necessary regulation do you think there is to ensure that companies that largely operate in secret with what data sets they have, what algorithms they build, and how they differentiate their services for different individuals, how would you ensure that fundamental rights are met when those services are developed?
So, as far I understand the question correctly, what should we have done for getting a better balanced situation? If we are using the structure what we have, then I would say we could have improved the pseudonymized data to being more creative with these and give a kind of an easy access to this data that business can create something out of it new. And on the other hand, we can have put more safeguards on the other side, not that individuals may be infringed by these. And this is what we haven't done. So we could have been more creative and adapting more the future world and more the reality. If we are looking here to this situation now regarding the consent, and I have been always a fan of being that people are self-responsible and took responsibility for their own life, etc., etc. But here in this case, I would say nobody is really reading terms and conditions. They are interested in using a device, they are interested in using a software, they are interested in using a free service, and therefore they are giving all the consent the companies are need. And this is why I would think this structure is giving up privacy because of technology developments. Everyone will install in their homes everything what's making life easier in kind of self-optimizing your life. The watcher apps which will come and reminds you on birthdays and emails and bank transfers or whatever. This is also optimizing your life, and everyone will consent to these. But you are open then your calendar, your bank account, and your interest if you would like to change your job or whatever, and everyone is consenting without having in mind what this means. And therefore, I would say we are giving up our privacy because of this structure. And this is what I would say we could have been better if we would have had the courage at the end in saying, oh, yes, let's do it better. But there was the pressure on the timeline and political pressure, etc., and therefore I would think we could have done this better.
I have to say that really one of the biggest problems in all that harmonization are the cultural national differences. If you look at the digital scoreboard, then you see that concerning understanding of risks and taking risks in digital area, Germany and my country, Estonia, are on opposite sides of the scale. We in Estonia, we have the common electronic identity, which we could use everywhere in banking, and also we have a mobile identity. We are making through the internet the taxation recording, and we are not afraid that somebody will come and then disclose everything and so on. As I said, it is a matter of culture, it's a matter of trust, and we have to develop the digital culture. Because it's the same in the so-called non-virtual lives. It is possible to come in door and take everything from the other apartment, but we don't do it. We don't do it. It's part of our culture. And the same should be in digital world, that you just don't steal the data of other person. And there cannot be the so detailed rules for every person. There should be laws and culture. And I suppose that in order to go on with digital single market, for example, I, with my experience from Estonia, will say that without all European electronic identity, we will not have digital single market. But to have all European electronic identity, which is really part of pseudonymization, because I have my electronic number, that's my pseudonym. I freely use it everywhere. And then I can call to bank and say my identity number and then have all information of what I need and so on. So it is part of the culture. And I suppose that creating this frame, even if it's not, say, sufficient, we are pushing toward this common culture. But the next steps have to be done in practices, and practices connecting with these kind of things. And pseudonymization as part of this digital life could be trustworthy. And I will not agree with Axel, with you, because we have put in DPR very clear, say, provisions when pseudonymized data could be tackled, when there are safeguards that pseudonymization cannot be cracked up very easily. There is now mathematicians developing special technologies of the registry data computing which preserve pseudonymization and so on. So I suppose that it's going on. It is a challenge for people in the area, in the field, and technological development is very much pushed on by the GDPR, because we have there the European standards, European certificate, and I suppose that this privacy technology will become one of the biggest competitive advantages for the firms. With our contacts with big firms during the process, I have seen how really eager they are to implement there.
Okay, well, we have 2 minutes.
Okay, I think that GDPR is a very important step forward, but we have 2 years period for implementation, and we need to make it very wisely, using all tools for understanding and all possibilities for understanding the context, because this is not the separated solution, GDPR. We need to understand that the context related to digital single market, digital revolution in Europe is very important, and this is the part of this. This is the part of this, I think, that in 1-2 years we will discuss how to support and harmonize consumer rights all over the Europe. And it will be the second part of making, of building the trust between consumers and business and among consumers. So I think that we need to use these 2 years for good implementation with thinking of all partners, but also I think that we need to consider how the digital is changing the world. So it means that the big data is the key challenge, and we need to adjust some solutions if it will be possible. And we need also this European board, an authority for interpretation, because it was put in the regulation for interpretation some new challenges related to new technologies, how to implement new technologies, and on the other hand, how to respect fundamental rights as privacy is.
Thank you very much, and forgive me as chair for not allowing more any questions. I think that the passion and interest in this subject is evident from all of the contributions, and I'd like to thank them very much. One final thing is that Jan's book, Hands Off Our Data, is just outside the hall, and he'll be signing copies if you'd like to get a copy of that. And just leaves to thank again our excellent panellists. Thank you.